critical difference is that the Sentencing Council should be an advisory body doing the research, preparing draft guidelines, putting these guidelines before the appeal court endorsing, if it thinks fit, these particular guidelines, and it then sanctioning them so that they were such that sentencing courts were bound to have regard to them. That's the way I would put it.
Chose not to sanction them.
Yes.
Where are we?
Well, they would no doubt have to explain why they were not sanctioning them, and they might then have a power to remit back to the Council for reconsideration in the light of its views. And there might be an amendment, or they could perhaps sanction them subject to amendment. That's another possibility.
Okay. Certainly.
You've told us this morning about what happens at present when guidelines are being prepared and issued. Do you, at present, is there any account taken from informed representatives when whatever panel or the judges would be sitting considering that?
Well, not from the members of the public generally. I mean, I think we do take into account, for example, representations that may be made by the Lord Advocate as prosecutor. And I know, and I can think of a particular case which arose out of an appeal against an allegedly unduly lenient sentence in a rape case, in which the Lord Advocate put before us a number of factors in relation to public concerns and so on and so forth, in which we had to make a distinction under the new regime in relation to the constitution of rape, between rapes which were of a particularly brutal character on the one hand and those which had not that particular character on the other hand, so that we have information from the prosecutor, as well as anything that may be said in behalf of a particular accused, to input into these matters. But not from the public generally, at the moment.
Okay.
Right, we'll move on just in a moment. Lord Justice Clerk, have you anything to add at this stage? You'll no doubt wish to make the point that judges too are members of the public and do speak to people in the course of their everyday lives.
We have our finger on the pulse, there's no doubt about that, contrary to any other popular belief, simply because of the length of our experience as practitioners and judges, and also from the number of cases that we deal with day in and day out in the appeal court. Could I just mention one point in supplement to what the Lord Justice General has said? There is a role in Scotland for a sentencing council, in my opinion, but it's not this particular one. What we really need is some hard research to establish what the effect of sentencing actually is. At the moment, the courts have got a wider range of disposals before them than they've ever had at any stage in history. And what we really need to know is how do you measure the success of these disposals? And if you have a criterion for the success or failure of them, what is actually happening out there in the field? That is where some useful research could be done. And a sentencing council could do a great deal in that matter. It could also look at developments in sentencing in other jurisdictions in the world and see what other imaginative ways have been devised in other countries. And that would give them a basis to enable the sentencing of our court to be better informed, and likewise in the sheriff courts too. But of course that would be an essentially research and advisory body, which is rather different from the conception that we have in this draft.
Thank you. Turn now to the question of short custodial sentences with Robert Brown.
Yes, I've got one or two points to make in this area, if I may. And I think, again, it's the constitutional issue that underlies this. Section 17, of course, talks about the short sentences being, to some extent, replaced by community sentences. Does that raise any issue of an undue interference with the freedom of the judiciary in relation to sentencing issues? I mean, it's a sort of policy direction, a sense of a relatively substantial nature.
I approach this matter with some sort of hesitation, because the experience of the High Court is mainly dealing with High Court sentences rather than short sentences, which is a matter very closely involved with the exercise of Shreveport and Justice's jurisdictions. I don't think I have a particular problem with that aspect of matters, if it is simply regarded as a presumption. The position, I think, at the moment is, and no doubt the sheriffs will be able to expand on that, is that the sheriffs do not readily sentence people to short sentences, but they recognise that there are a range of circumstances in which short sentences are the only option truly available to them, particularly with people who have been given all manner of options in relation to non-custodial disposals in the past, and have simply set their faces against that, being prepared to answer to the community for their failures. And there are other cases in which there are repeat offenders, or particularly road traffic cases in which somebody has continuously driven without a license and things of that sort, in which the short, one hopes sharp, sentence is one which may bring home to the individual the importance of complying with the law. So I don't think I have a difficulty in principle with the matter.
Thank you very much. Can I develop some of the points you've made in paragraph 10 of your submission, particularly, first of all, the one that relates to your fear that mandatory directions to the court by a non-judicial body might undermine judicial independence under the ECHR. Can you give us a bit of a flavour of what your fears and concerns might be in that area?
Well, the ECHR is concerned with the requirement that every person who has his criminal as well as his civil position to be adjudicated on is entitled to an impartial and independent tribunal. And that includes circumstances in which a person condemned in a criminal case is being disposed of by a judicial office holder. So the judicial office holder must be an independent tribunal. And I am concerned that if the judicial office holder is constrained to a significant degree by dictates of a body which is not itself a judicial body, and indeed is not a democratic body in the sense of an elected body itself, then there may well be an issue arising in these circumstances as to whether or not a particular individual has had the benefit of an independent tribunal dealing with his disposal.
And is it fair to say that that casts an element of uncertainty on the whole proceedings, apart from the issues of principle?
In my view, it certainly raises a question.
Yes. Can I develop a slightly different point, which really comes on from that? In the representations by the sheriffs, they make some concerns about the composition of the body, again, the sentencing council, and they make reference to the fact that the Lord Advocate is someone who has to be consulted about the draft guidelines, while the judiciary does not, and that there will be a prosecutor on the council. There's a sort of suggestion, there's a prosecutorial bias, if you like, to the arrangements. Do you have any concerns about that aspect of the matter raised by the Sheriff's Association?
One, I suppose, starts from the premise that in general, or at least traditionally, the prosecutor or the Lord Advocate has not been concerned with sentence. In our jurisdiction, the prosecutor doesn't, as in other jurisdictions, for example, propose that a particular sentence be imposed by the court. Nonetheless, the Lord Advocate does have an interest in what the courts do, and that is illustrated by the fact that the statute allows her to appeal to, without leave, allows her to appeal to the High Court against something which she contends to be an unduly lenient sentence. So that I don't think I have a particular difficulty with recognising that